But there is also, among this body of evidence, a large number of videos that we have submitted to you where the court can see with its own eyes the horrific abuse. You'll find the reference pages for those videos in your judge's folder at tab 4. These videos were posted on social media by Azerbaijani servicemen or others and were then picked up by news sources. For some of these videos, we added English subtitles so that the court may understand what is being said. I anticipate that you will find these videos deeply disturbing, not only from the atrocious acts being committed, but in the clear hatred being shown to persons of Armenian origin. Tragically, it's well known that a number of military and civilian detainees of Armenian origin have not just been inhumanely treated, they've also been executed. These executions are also evidenced by witness accounts and other information. And these executions are also evidenced by videos that we've submitted to the court. Here, too, the court will find these execution videos shocking, graphic, reprehensible, and riddled with hate speech. And sadly, even in death, the abuse continues, as there are also numerous videos of the bodies of deceased Armenian soldiers being mutilated by Azerbaijani soldiers, done in conjunction with hateful slurs against the Armenian people. We urge you to review these videos as you consider the fate of the 45 acknowledged detainees and of those detainees who have not been acknowledged. But to highlight how the suffering seen in these videos directly connects to the current detainees, I wish to describe one of the videos, which is found at Armenia's Annex 69. This video demonstrates the suffering of one of the acknowledged POWs, ΟՒՂԻΓ Mekirchen, who is the second POW listed in tab 3 of your folders. In the video, which may have been taken shortly after Mekirchen and other Armenian soldiers were taken captive, you will see Mekirchen lying on the ground along with the other POWs. Mekirchen has a bullet wound in his left hip and tailbone. Despite that wound, he is blindfolded and he is restrained. He is clearly hors de combat, yet his Azerbaijani captors kick him in the back, they step on his head, and they poke him with a sharp rod. One of his captors asks, "Where is his finger? Shall I cut it?" Mekirchen begs not to be harmed. He says, and I quote, "Don't shoot. Please, don't kill me." In the video, the other Armenian POWs fare no better with such treatment. The Azerbaijani soldiers also step on them, kick them, poke them with the sharp rod. These POWs, as you will see, are clearly afraid. One of the POWs begs not to be harmed. One of the captors responds with hateful language. He says, and I quote, "You're going to keep on begging like this a lot. You, the disgraceful people, pimps, faggots." Towards the end of the video, one of the captors says about one of the POWs, "Cut it, cut the finger." Another captor approaches that POW with a sharp metal rod. As the POW, blindfolded, bound, and prostrate, begs not to be touched. The captor then places the sharp rod against the POW's fingers and then pulls back just before the video ends. I note that the corroboration of this abuse, and specifically of McCurchin, can be found in other videos that we have provided to the court. Members of the court, we submit that there's an ample basis for the court to conclude in this proceeding, as it did in the Tehran hostages case, that continuance of the situation, the subject of the present request, exposes the human beings concerned to privation, hardship, anguish, and even danger to life and health, and thus a serious possibility of irreparable harm. Another form of this abusive treatment bears noting. Azerbaijan has subjected these detainees to sham criminal proceedings in which individuals are charged long after they should have been repatriated and then tried and convicted in a matter of days, often in a language they do not understand. These convictions were typically based on charges that are not triable under the laws of war. For example, it makes no sense in the context of a ceasefire agreement that leaves armed forces positioned in places opposite each other for one side to charge the soldiers of the other side with illegal border crossing and illegal carrying of firearms. Likewise, it makes no sense to convict someone as a mercenary when he is a national of one of the belligerents. The two POWs captured in October 2020 were convicted for acts that allegedly occurred 3 decades ago, which at the time were never pursued by Azerbaijani authorities, and in any event were overtaken by the obligation to repatriate. Moreover, some of these convictions apparently were based on confessions, yet there is ample evidence of Azerbaijan coercing confessions through torture. The court simply cannot countenance a justification for detaining POWs and civilians that is tainted by such conduct. That these criminal proceedings are a sham is also demonstrated by the fact that Azerbaijan blithely releases some of these so-called criminals whenever it is able to extract something from Armenia in exchange. As I previously noted, 6 POWs were captured on May 27th of this year. Azerbaijan rushed to charge them with crimes on 28 and 29 May. Then, just 2 weeks later, on 12 June, 4 of those POWs were released as part of a group of 15 Armenian POWs. Why release POWs who are allegedly criminals? Well, they were released by Azerbaijan so long as Armenia provided a map detailing the location of mines in Agdam. Such conduct is arbitrary, and it speaks volumes about the nature of Azerbaijan's so-called criminal proceedings. Indeed, similarly, Azerbaijan charged a group of Armenian POWs with the crime of illegally crossing the border, and on 2 July 2021, sentenced them to prison. Yet the very next day, on 3 July, Azerbaijan released 12 of them as part of a group of 15 POWs, this time in exchange for maps of mines in the Fuzulai and Zangala regions. The 3 others in this group still had their trials pending, yet they too were repatriated. The arbitrariness of Azerbaijan's so-called criminal proceedings continues in that all 15 of those released POWs were from the Kurtzabird group, yet many others from that same group remain detained. Hence, the fact that the continued detention of the POWs has nothing to do with actual criminality is readily apparent from Azerbaijan's willingness to repatriate some POWs on some occasions whenever Azerbaijan believes it has extracted something from Armenia, while refusing to repatriate other POWs who were captured for the same acts and at the same time and in the same place. This is not a situation of applying criminal law fairly and judiciously. It's using criminal law arbitrarily as a subterfuge for prohibited discriminatory conduct. Finally, on the factual discussion, while it's reported that Azerbaijan is allowing the ICRC to visit these 45 detainees, there is also evidence that Azerbaijan is seeking to hide the other detainees and to hide its abuse of all the detainees from the ICRC and from others, making their repatriation all the more urgent. For example, the rapporteur for the Parliamentary Assembly of the Council of Europe was repeatedly denied permission to visit these detainees. I turn now to the plausibility of the rights at issue. Azerbaijan has an obligation to repatriate the POWs. Indeed, this is one of the most important obligations of international humanitarian law. Azerbaijan's disregard of that obligation is ethnic discrimination, pure and simple. Whereas virtually every other country in the world takes quite seriously the general obligation to repatriate all POWs after the cessation of hostility, Azerbaijan has not, because of its policy of hatred toward persons of Armenian ethnicity. As was apparent from the presentation of Mr. Salonides, persons of Armenian ethnicity are viewed by the Azerbaijan government as subhuman, as meriting a disgraceful and demeaning trophy park, but as not meriting the fundamental right of repatriation. For Azerbaijan, the POW's value is not to be found in human dignity. Rather, their value is as a bargaining chip. They are pawns for Azerbaijan to advance its political interests, an especially pernicious exercise of ethnic discrimination. Article 1, paragraph 1 of the CERD defines racial discrimination in broad terms to include any distinction, exclusion, restriction, or preference based on race, color, descent, or national ethnic origin. Thus, restrictions based on ethnic origin are a form of racial discrimination. Article 2 then obligates states parties not to engage in any act or practice of racial discrimination against persons or groups of persons. Article 5 furthers the fundamental obligations set out in Article 2 by making clear that, and I quote, states parties undertake to prohibit and eliminate racial discrimination in all its forms and to guarantee the right to everyone without distinction as to ethnic origin to equality before the law. Equality before the law. Moreover, Article 5, subparagraph D2 specifically protects the right to leave any country and to return to one's country. We submit that it is much more than just plausible that these rights under the CERD are being denied to the POWs. The government of Azerbaijan has directly ordered their continued detention. There's no issue of private action here. This failure to repatriate is a denial to persons of Armenian origin of their rights under the CERD to equality before the law. In this instance, before or under international humanitarian law. Azerbaijan may not, under the Third Geneva Convention, refuse to repatriate these POWs. Many organizations and observers have already reached that conclusion on the merits. Indeed, the Third Geneva Convention itself prohibits racial discrimination against POWs. When one considers the general background of Azerbaijan's hateful views regarding persons of Armenian origin, along with the inhuman and degrading treatment of these POWs, and along with the occasional use of the POWs as bargaining chips, all such circumstances strongly demonstrate that this failure to repatriate is not just plausibly racial discrimination, it is racial discrimination in the form of a denial of equality under international humanitarian law. Now, you may hear from Azerbaijan this afternoon that all these POWs are criminals and that their detention has nothing to do with ethnic discrimination. Yet all the evidence points towards ethnic discrimination, and no one is accepting Azerbaijan's claim of criminality. UN human rights experts don't accept it. The European Parliament does not accept it. The Parliamentary Assembly of the Council of Europe and its rapporteur do not accept it. Rather, all of them have called for the expeditious repatriation of these POWs, as have many governments. Time does not allow me to describe in depth the plausibility of the POW's rights under the CERD not to be beaten, tortured, or otherwise physically or mentally abused. But here, too, we submit that it is much more than just plausible that such treatment violates CERD Articles 2 and 5, and in particular Article 5, subparagraph B, which protects the right to security of person and protection by the states against violence or bodily harm. The POW's treatment before Azerbaijani courts also clearly implicates CERD Article 5, subparagraph A, which recognizes the right of equal treatment before the tribunals and all other organs administering justice. And the overarching Article 5 right to equality before the law is further implicated given that Azerbaijan's inhuman and degrading treatment is a denial to an ethnic group of their rights under international humanitarian law and also under international human rights law, including prohibitions on arbitrary detention, on torture, on inhuman and degrading treatment, and as well as the freedom to leave any country and the right to a fair trial. As is the case with the POWs, it is more than plausible to maintain that the government of Azerbaijan's refusal to repatriate the 3 acknowledge civilians is a denial to persons of Armenian origin of their rights under CERD Articles 2 and 5 to equality under the law, including the security of their person and to the right to return to their country. And with respect to the equality under the law, Azerbaijan simply has no basis under either the Fourth Geneva Convention or human rights law to refuse to repatriate these civilians or to treat them inhumanely. Again, many organizations and observers have already reached that conclusion on the merits. Under the Fourth Geneva Convention, civilians are protected persons, and if interned during the conflict, they must be released after the cessation of hostilities. They must be treated humanely, without any distinction founded on race. They must be protected from murder, torture, or brutality. The taking of civilians as hostages is forbidden, and they shall not be deprived of the rights of a fair and regular trial as prescribed by the Convention. And similar protections for these civilians arise under the previously noted human rights law. Madam President, the plausibility of the rights claimed under the CERD with respect to POWs and civilians that Azerbaijan has not acknowledged, but has also treated inhumanely and has not repatriated, also flows from what I just said. Although these persons are not acknowledged by Azerbaijan, there is ample evidence that they were taken into captivity, that they have been abused, and obviously that they have not yet been repatriated. For the reasons previously indicated, it is more than plausible to regard their treatment as a denial to persons of Armenian origin of their rights under Articles 2 and 5 of the CERD, notably their rights to equality under the law, to return to their country, and to the security of their person. Madam President, that concludes my presentation. I ask that you now call on Professor Dargent.
I thank Professor Murphy for his statement, and I now invite Professor Pierre Dargent to take the floor. You have the floor, Professor.
Thank you, Madam President. Madam President, distinguished members of the Court, it's always an honor to speak before you, and a particular honor to do so today in the present circumstances to support Armenia. My presentation will be devoted to the necessity to protect the right of Armenia and Armenians to enjoy, without prohibited discrimination, their cultural and religious heritage. Article 2 of the Convention on the Elimination of All Forms of Racial Discrimination obliges the states parties to recall, and I quote, to engage in no act or practice of racial discrimination. Furthermore, Article 5 of the Convention imposes that one ensure without prohibited discrimination the enjoyment of the rights stated under it. Amongst those rights is the right to freedom of religion and, I quote, also the right to equal participation in cultural activities. It cannot be denied that the right to freedom of religion includes the right to practice one's religion in habitual places of worship, and thus the right to see these places respected and preserved. Likewise, the right to participate in cultural activities implies that the heritage serving the purposes of such activities be respected and preserved. And furthermore, of course, many places of worship are part of the cultural heritage. Thus, the religious and cultural heritage is likely to be protected under the Convention when it is established that it is attacked for a ground forbidden by it. The rights that Armenia asks you to protect in matters cultural, not only are they plausible ratione materiae in the light of the Convention, but also, and I will come to this, with regards to the facts On the 8th of October 2020, Madam President, the Holy Saviour Cathedral in Shushi was twice bombed. The first attack took place around 12 o'clock, the second around 5 p.m., whereas there was no combat or other bombardments around that place on that day. These are well-documented facts, and following an inquiry undertaken in situ, Human Rights Watch concluded that the cathedral had indeed been intentionally bombed by two well-targeted volleys, and everything could lead one to think that these attacks were perpetrated by Azerbaijan that was besieging the city. To date, the defendant has not adduced any other credible explanation about these acts. The Cathedral of Shushi was coldly and deliberately pounded twice on the same day, so that the deadly message thus sent be perfectly clear. The Armenians do not have any place in Nagorno-Karabakh and will never be in security there, not even in their most sacred spaces. The bombing of the cathedral in reality was just a warlike prelude of a policy that was to manifest itself immediately after the ceasefire and extend till today. Madam President, evidence of cultural destruction that I shall adduce are numerous indeed. Armenia's application with regards to this contains many references to available documents on the internet. Some have been reproduced in our annexes. With the corroboration of photos or videos, this evidence appeared in the media and social networks. Tallying with each other, this evidence was collected and checked by satellite images through Caucasus Heritage Watch, a research initiative undertaken by archaeologists from the universities of Cornell and Purdue in the United States. The complete reports of these archaeologists are to be found in your hearing file, tabs 13 and 14. A few days after the 10th of November, the cathedral was yet again the subject of racist attacks, during which its walls were daubed with graffiti, whereas the statues of angels ornamenting the railings surrounding the cathedral were deliberately damaged before they disappeared. Since then, Azerbaijan has undertaken what it calls restoration of the cathedral work. It removed the spire on top of the choir tower so as to return it to its original architectural so-called style and to return to the historical image of the town. But let's look at this more closely. Built between 1868 and 1887, when the region was part of the Russian Empire, here is the cathedral now on screen as it originally appeared, with its spire before the anti-Armenian pogroms of March 1920. Following the ethnical recomposition of the city caused through these dramatic events, the spire of the cathedral was removed and the religious building ceased to be maintained during the Soviet period. The cathedral resumed its original aspect in 1998 before it was bombed on the 8th of October 2020. Since then, Azerbaijan claims that restoring the cathedral could be done by removing its spire. Distinguished members of the court, in decapitating Shushi Cathedral, Azerbaijan intends to make it visible as from Stepanakert and reestablish the situation in which it was abandoned following the pogroms of 1920. And thus, indirectly, it recalls this memory. Claiming to reestablish the historical image of the city, Azerbaijan indeed reveals its policy of racial discrimination after having voluntarily destroyed the cultural heritage, the Armenian cultural heritage, by bombing it. Azerbaijan is modifying what remains of it in order to diminish its presence. Through a letter of last Friday, transmitted less than 2 days ago, the Azerbaijan Vice Minister of Culture affirms that the work of restoration was undertaken in consultation with international experts. However, this internal letter in the government of the defendant doesn't prove anything unless it be its depravity. It's this letter, which you are asked to keep confidential, although it concerns a monument, manifestly was written and very cautiously formulated, framed for the purposes of the present case. And as you'll note, it's addressed to the person who's the agent of Azerbaijan in the cases submitted to your scrutiny. Furthermore, this letter states that experts would be consulted without actually naming them, nor saying anything about their visits or reports. And above all, it does not, this letter, indicate that Azerbaijan intends to rebuild the spire of the cathedral that its double bombing did not, however, succeed in striking down. The official position of the defendant is thus that the cathedral, in its original form, was without a spire, as you saw. And as you can see it again on screen, nothing could be further from historical truth. Still in Shushi, the Armenian Church of St. John the Baptist, also called the Green Chapel, was decapitated after the trilateral ceasefire declaration. In the village of Merkavan, which the defendant calls Jebrail, the BBC reported about the complete destruction of the church after it was vandalized by Azerbaijani soldiers. On the 27th of March of that year, Azerbaijani soldiers, through mockery, profaned the church of St. Yegishi in the village of Matagis, as you can see looking at the video under tab 5 in your hearing file. Very soon after the declaration of the 10th of November, Azerbaijani soldiers also went to Armenian cemeteries to cast down tombs, smash them and profanate them. Such incidents were reported on the 26th of November 2020, and then when spring came back in May 2021, in 5 places at least. In Adrut, north of Shushi, at Metztacher, at Taravard, at Shekhnach, where the old Armenian cemetery that went back to the 18th century was totally razed. Evidence of such destruction are taken up in your hearing file, tabs 6 to 10. The destructive fury of Azerbaijan also covered kachkars, a characteristic of religious art in Armenia, whose origins go back to the 4th century. A kachkar is literally a stone with a cross, either a stele about 1.50 meters high, rectangular in shape, carved in low relief with one or several crosses, surrounded by ornamental decoration of human figures or inscriptions in Armenian. And since 2010, the kachkars, Armenian kachkars, are on the list representing the immaterial cultural heritage of humanity. In Shushi, the kachkar of the bombed cathedral was then disfigured and destroyed at late April this year. Furthermore, in territories that Azerbaijan claims to have liberated, kachkars are torn down. This was the case notably on the 12th of January 2021 in Armenian, where the Azerbaijani armed forces knocked down a kachkar through a military truck, as you can see in tab 11 in your hearing file. The cemetery at the north of Sushi, which was very considerably destroyed, had 2 kachkars of the 12th and 13th centuries. Madam President, distinguished members of the court, such a gratuitous and discriminatory destruction seeks to erase the Armenian cultural presence in Nagorno-Karabakh. Further destruction is directed against Armenian memory. late March this year, in Shushi, Azerbaijan destroyed the monument commemorating the genocide of Armenians perpetrated by the Ottoman Empire, which is to the left on your screen. Denying the existence of genocide, the defendant considers no doubt to be entitled to destroy this monument because it commemorates an event that, according to it, did not occur. To the right of the screen, you can see the location of the monument without the monument and without the inscriptions in Armenian on its surrounding wall. This photograph was taken during the presidential visit in June 2021. A flagpole, as you can see, with the flag of Azerbaijan has replaced the monument to the Armenian genocide. There could be no stronger symbol. President Aliyev making of the rewriting of history a central point in his ethno-nationalistic and discriminatory policy. Distinguished members of the court, there is no place, no room in the territories controlled by Azerbaijan for what makes and symbolizes Armenian identity. Madam President, during his speech before the General Assembly on the 23rd of September last week, thus after your court was seized by Armenia, and on the very day Azerbaijan filed in reply its own case introducing proceedings, President Aliyev on that date said this in his discourse to the General Assembly. In Azerbaijan, we cherish and support multiculturalism as a way of life. Azerbaijan is considered as an example of tolerance and peaceful coexistence of representatives of various religious and ethnic groups living in our country. End of quote. No doubt that your season prompted the defendant to present himself before you under the most flattering light. However, such official discourses of tolerance and inclusion, as well as the very recent exhibits established for the purposes of the present case, obviously sound hollow when they are confronted, as they should be and must be, when they are confronted with the reality of the facts that my colleagues and myself have just related. Beyond the window-dressing speeches, these facts reveal the genuine nature of the Azerbaijani political regime and its hateful practices contrary to the convention. Madam President, distinguished members of the court, the official discourse of Azerbaijan is all the more misleading, and the destructions of the Armenian heritage in Nagorno-Karabakh are all the more foreseeable since they occur in a particularly worrisome context. And apropos this, I should like to propose 5 indisputable contextual elements. On the one hand, and you will have noted this through the chronology of the events, Azerbaijan undertook the cultural destruction and other breaches reported by my colleagues. At the time, it was engaged in negotiations started by Armenia, pursuant to Article 22 of the Convention. Baku many a time declared to undertake these negotiations in good faith, though all the while accusing Armenia of not doing so. The duplicity of the defendant will not have escaped your attention. Furthermore, another flagrant case of duplicity, the official discourse of the defendant destined to chancelleries is very different from that aimed at its national public opinion. As Mr. Salonidis recalled, 4 days hardly after his speech before the General Assembly, President Aliyev addressed himself to his people by stoking anti-Armenian hatred, using very discriminatory and shocking terms. Furthermore, a third contextual element which is particularly worrisome, the destructions and profanations in Nagorno-Karabakh were and are still perpetrated in camera. UNESCO has still not been able to access the Armenian cultural sites, whereas the Deputy Director General of the organization on the 21st of December declared in 2020 only the response of Azerbaijan is still awaited for UNESCO to proceed with the sending of a mission to the field, end of quote. On the occasion of his New Year's message, in other words, 10 days after the solemn appeal of UNESCO, President Aliyev accused the international organization of lying and practicing a policy of double standards. And we know, too, since less than 2 days, we know that in August this year, Azerbaijan set aside a visit of UNESCO once again because notably its terms of reference mention Nagorno-Karabakh, an appellation which is henceforth rejected by the defendant, whereas the trilateral declaration of the 10th of November, which is binding upon it, uses that expression no less than 5 times in 9 paragraphs. So then, distinguished members of the court, that is the state of mind in which the defendants tackle the question of preservation of cultural heritage. It uses this to push its political agenda and force the hand of the international organization. And then the fourth element, contextual element that need be recalled, is due to the fact that Azerbaijan, alas, is accustomed with cultural destruction when it's a matter of attacking the Armenian historical heritage in the Autonomous Republic of Nakhichevan, located in the southwest of Armenia. Azerbaijan has committed innumerable cultural destructions since its independence, especially in 2005. Baku raised literally the old cemetery in Jura, which had thousands of khachkars, the largest collection in the world. These facts and others were duly documented, and we will return to them when we come to the merits of the present case. The International Council for Monuments and Sites, as well as the European Parliament, deplored and denounced what the press qualified as the worst cultural genocide of the 21st century, to quote it. Now, when faced with legitimate such condemnations, the reply of the authorities in Baku was to try to attempt to change reality. So from historical revisionism to negationism, there is indeed only one step that Azerbaijan blithely takes through the voice of its ambassador in London, whom I quote, "First and foremost, we need to make it clear that there is no such thing as Armenian heritage in the Nakhichevan Autonomous Republic simply because Armenians never lived there. Non-existing sites or cemeteries cannot be destroyed." And finally, and this is the fifth contextual element to reinforce the need to urgently to protect the Armenian heritage. Well, finally, Baku deploys the same historical revisionism with regards to Nagorno-Karabakh. Indeed, the destructions and profanations upon religious and cultural Armenian sites is accompanied with an official discourse seeking to make one believe that the Armenian heritage of Nagorno-Karabakh was a usurped heritage because the Armenian churches are monuments that belong to the Udi people, an Albanian Caucasian people whose trace we find in antiquity, and that the propaganda of Baku considers as being proto-Azerbaijani, posing in camouflage outfit before the church of St. Asastatsin in the village of Tsakuri. In March 2021, President Aliyev launched him into a diatribe propagating such a theory, claiming that the church was a former Albanian church upon which Armenian inscriptions would have been placed at a later date. The internet site of the presidency translated the speech of the head of state on video and film, and this is accessible on YouTube, tab 22 of your file. So changing historical narrative in order to justify such cultural destructions and to lessen the century-old presence of Armenians in Nagorno-Karabakh, Azerbaijan is also changing its administrative language. Referring to two of its recent decrees, President Aliyev declared during his speech of the 23rd of September last before the General Assembly, he stated that, and I quote, "There is no administrative territorial unit called Nagorno-Karabakh in Azerbaijan." Distinguished members of the court, what this apparently anodyne change, since it's a bureaucratic change, and what it conceals is basically the discriminatory, destructive and revisionist attitude of Baku with regards to authentic testimony of centuries-old Armenian presence in the territories under its control, that is to say, Armenian churches, Armenian cemeteries, kashgars, and all monuments recalling such a presence. The conduct of Azerbaijan is manifestly contrary to Articles 2 and 5 of the Convention, because it is clear that the sole and unique reason for which Azerbaijan is striving as it does with regards to Armenian cultural heritage is precisely because it is Armenian. Distinguished members of the court, I would like to thank you for your kind attention. May I ask you, Madam President, to call upon Mr. Larry Martin to the bar.
I thank Professor Darjan for his statement, and I now invite Mr. Larry Martin to take the floor. You have the floor, Mr. Martin.
Madam President, distinguished members of the court, good morning. It is an honor and a privilege to appear before you on behalf of Armenia. It falls to me today to address the issues of urgency and irreparability, and of the link between the rights for which Armenia seeks protection and the provisional measures we request. Fortunately, I can be brief. Nothing about what I'm about to say should be controversial. In fact, it all flows directly, inescapably, from my colleagues' presentations before me. The urgent need to protect Armenians from continued hate speech, to repatriate and protect Armenian POWs and detainees from further mistreatment, and to protect Armenian cultural heritage from erasure, all follows from the evidence as unavoidably as night follows day. The court has made clear that it will exercise its power to indicate provisional measures, quote, only if there is urgency, in the sense that there is a real and imminent risk that irreparable prejudice will be caused before the court gives its final decision, end quote. That condition is met, quote, when the acts susceptible of causing irreparable prejudice can occur at any moment before the court makes a final decision on the case. To be sure, not just any irreparable prejudice counts. What matters is that, quote, irreparable prejudice could be caused to the rights which are the subject of judicial proceedings, or the alleged disregard of such rights may entail irreparable consequences. At this preliminary stage of proceedings, the court is not required to, quote, make definitive findings of fact, or determine that cert has, in fact, been violated. To the contrary, the court need only determine that it is, quote, not inconceivable that a violation might occur, or that information before the court, quote, does not exclude the possibility that irreparable harm might be caused. All of these elements are plainly present here. On the issue of hate speech, as Dr. Salaniadis showed, Armenians have the right under CERD to be free of racial discrimination by Azerbaijan in all its forms, including racist hate speech. CERD specifically requires Azerbaijan, quote, not to permit public authorities or public institutions, national or local, to promote or incite racial discrimination. Yet, even so, President Aliyev, who inherited the job from his father and has held the highest office in the land for 18 years, continues to spew racist hatred to this day. As recently as last month, he said Armenians have, quote, a mental illness, and called them worse than animals and a, quote, depraved tribe. How does such hate speech threaten irreparable harm? Simple. Hate begets hate. And hate emanating from a state's highest authority begets more hate still. Dr. Salaniadis recalled that the CERD Committee has observed that, quote, racist expressions emanating from public authorities or institutions are of particular concern, especially statements attributed to high-ranking officials. As some of us have learned from our own recent national experience, hatred from the top, even in a nominally free country, operates as a kind of license that opens the floodgates, allowing other elements of society to follow suit. The obsessive and continuing expressions of hatred for Armenians coming from President Aliyev and other senior government officials thus constitute a disregard for the rights of Armenians that may easily entail irreparable consequences. They fan the flames of open racism that immediately imperil the rights of all Armenians, including those living in Nagorno-Karabakh and those still held in captivity. Indeed, such speech places them in even greater physical jeopardy than they already are. By actively fomenting an atmosphere of hate, President Aliyev and other senior government officials are making their physical and mental abuse even more likely. The ghoulish military trophies park is a perfect demonstration of the point. Open 6 days a week to anyone over the age of 6. The displays at the park teach Azeris young and old that it is not only permissible, but actually desirable to mock, degrade, and abuse Armenians. The park serves as an obvious signal that such mistreatment is condoned at the highest levels. Does anyone really think that the Azerbaijani soldiers responsible for guarding Armenian POWs and civilian detainees will miss the message? In short, the park badly exacerbates the already real and present threat to the detainees. Late Tuesday, less than 48 hours ago, Azerbaijan submitted an unsworn and strangely confidential document stating that the mannequins had allegedly been removed from the park, albeit 2 weeks after Armenia filed its request. And last night, it submitted yet another unsworn, confidential document claiming that the bullet-torn helmets had also been removed another week after that. Even accepting this extraordinarily belated evidence is properly before the court and can be credited, which we do not accept. None of it affects the urgency of the need to order the park closed. In the first place, Some images of the mannequins from President Aliyev's visit remain on the park's website, as you can see now. In the absence of a formal public undertaking made by Azerbaijan's agent before this court, there is no guarantee they will not be returned the moment these hearings are over. Even then, the park remains as a conspicuous symbol of hate, a celebration of Armenians' defeat. What other message could it possibly convey? The urgent threat of irreparable prejudice resulting from Azerbaijan's continuing wrongful detention of Armenian nationals is more obvious still. Professor Murphy explained that the rights in dispute in this case include the right of Armenian POWs and civilian detainees to the equal enjoyment of their individual rights, including, but not limited to, repatriation and the right to security of person and protection by the state against violence or bodily harm. Unlawful detention is inherently a form of irreparable prejudice. Those detained for months or years before you reach a decision on the merits in this case will never get that time back. This is not an exaggeration. As Professor Murphy explained, Azerbaijan has already sentenced many of the detainees to serve years in Azerbaijani prisons. The only way to avoid such irreparable harm is a provisional measure from the court ordering repatriation. Professor Murphy also explained that the evidence shows a clear record and practice of Azerbaijani authorities abusing Armenian detainees, soldiers and civilians alike. The gruesome videos that Armenia has presented to the court will haunt the nightmares of those of us who have watched them for a very long time. Given the lengthy prison sentences that Azerbaijan has issued, there is no doubt that the detainees are extremely vulnerable for an extended period of time to continued abuse by Azerbaijani guards. The need for the urgent intervention of this court to prevent further irreversible harm is almost too obvious to say. If the clear and present threat of imminent psychological trauma, bodily harm, and even death does not warrant the indication of provisional measures, it would be hard to imagine what would. Indeed, the court has repeatedly found the requirements of urgency and irreparability met in situations where there were serious threats to human life and safety. In Georgia v. Russia, the court indicated provisional measures where, quote, violations of the right to security of persons and the right to protection by the state against violence or bodily harm could, quote, involve potential loss of life and bodily injury. Also relevant was the fact that the circumstances were, as they are here, quote, unstable and could rapidly change due to, quote, ongoing tension in the absence of an overall settlement to the conflict. And of course, in the hostages case, the court ordered the, quote, immediate release without any exception of all persons of United States nationality who had been held hostage. It did so in light of, quote, the privation, hardship, anguish, and even danger to life and health to which they were exposed. These are just examples, but they are enough to show that the court has long recognized that protecting individuals from harm is the quintessential circumstance warranting the indication of provisional measures. Armenia respectfully suggests that the court should do exactly that here to protect the remaining detainees in Azerbaijani custody. The urgent need for interim measures to protect Armenian cultural heritage is equally clear. Professor Darjan showed that Armenia's rights in dispute include the right to access and enjoy cultural heritage. That right includes the right to have that heritage protected, not destroyed, vandalized, or have its character altered. Yet, as Professor Darjan also showed, that is exactly what Azerbaijan is doing in conducting an ongoing campaign to erase the evidence of Armenia's presence from its territory. Just by way of example, revolting as it is, satellite photos make clear that between 12 April and 18 June 2021, a historic Armenian cemetery in the village of Sekhah was razed to make way for the construction of a road. Azerbaijan is literally paving over Armenian history. The risk here is real and ongoing for the reasons Professor Darjan explained. But the extent of the risk also cannot be understood without some mention of the historical context. As set out in our application and request for provisional measures, the relationship between Armenia and Azerbaijan has long been complicated, to say the least. As also set out in our application, even before the most recent armed conflict, Azerbaijan was prolific in its effort to erase any vestige of the Armenian presence from its territory. We refer to a number of examples in footnote. The continued spewing of racist hate speech by President Aliyev and other senior officials only exacerbates this real and present risk. Indeed, by refusing even to acknowledge the existence of Armenian cultural heritage, President Aliyev is directly promoting a climate that is even more conducive to the hate-filled destruction of that heritage. In concluding on this point, I note that the court has, in the past, ordered provisional measures to protect property and other tangible items from destruction. In the recent Cambodia v. Thailand case, it ordered measures to ensure that, quote, no irreparable damage is caused to property, including a UNESCO World Heritage Site. And in DRC v. Uganda, it did so in circumstances where, quote, assets and resources in the area of conflict remained vulnerable. We respectfully submit that the court should follow these examples and similarly order provisional measures to protect Armenia's cultural heritage from the very real and very urgent risk of irreparable prejudice. That brings me, Madam President, to the second and last part of my presentation this morning, the requirement that the provisional measures we seek be linked to the rights whose protection we seek. On this subject, I can be even more brief. The requisite link between the relevant rights and measures is even more obvious than is the urgent threat of irreparable harm. We will not burden the court by reciting the full text of the provisional measures we request. They are set out in our request, and the distinguished agent will return to them at the end of tomorrow's session. Suffice it now to note that they fall into four broad categories that precisely dovetail with the rights whose protection we seek. The first category of measures we request relates to the Armenian POWs and other detainees. To put it simply, we ask the court to order Azerbaijan to release them, and pending that, to treat them humanely. As Professor Murphy explained, and I underscored a few moments ago, the rights whose protection we seek include, among others, the rights of the detainees under Article 2 to be free of racial discrimination in all of its forms, and under Article 5 to be secure in their person and to be protected by the state from violence and bodily harm. As in the hostages case, the only genuine way to protect that right is to order the detainees' immediate release. The widely confirmed reports of Armenian detainees being tortured and even executed in captivity, and Azerbaijan's wholesale denial of the same leaves no other option. Requesting that they be treated humanely in the interim is asking nothing more then that the rights in dispute be respected. The second category of measures we request relate to the hate speech coming from the very top of the Azerbaijani government in the disturbing military trophies park. In short, we ask the court order that the hate speech be stopped and the park closed. Those measures are directly linked to Armenia's rights under Articles 2, 4, and 7 of CERD. The third category of measures relates to the protection of cultural heritage. We ask that the court order Azerbaijan to protect Armenians' right under Article 5 to equal participation in cultural activities, including the right of access to and enjoyment of their cultural heritage, and to take measures to stop its destruction, vandalization, and alteration. The connection between those requests and the rights to enjoy one's cultural heritage, as outlined by Professor Darjan, is, again, almost too obvious to state. The fourth category of measures we request is more general. We ask that the court order Azerbaijan, 1, to take measures to protect relevant evidence, 2, take no action that will aggravate or extend this dispute, and 3, submit regular reports on the steps it has taken to comply with the court's ultimate order. The first of these, the order to preserve evidence, is linked to the rights whose protection is sought in the sense that it is necessary to ensure that Armenia has a full and fair opportunity to present its case that Azerbaijan has violated those very rights. Without it, there is a genuine risk that Armenia's ability to vindicate those rights will be compromised. All the more since Azerbaijan has control of most of the first-hand evidence. The second and third of these general requests are largely de rigueur in circumstances like these. An order not to aggravate or extend the dispute is entirely customary, and an order for regular reporting is essential to ensure that Azerbaijan is genuinely implementing the court's order and respecting the rights of Armenians that are the subject of that order and our request. Madam President, for all these reasons, there is a very urgent risk of irreparable prejudice warranting the court's exercise of its extraordinary power to indicate provisional measures. The measures we seek, moreover, are linked to the very same rights whose protection we seek. Thank you for your kind and patient attention. That concludes Armenia's first round presentations this morning.
I thank Mr. Martin, whose statement brings to an end the first round of oral argument of Armenia, as well as this morning's sitting. The court will meet again this afternoon at 4 p.m. to hear the first round of oral argument of Azerbaijan. The sitting is adjourned.